guys, welcome over here. And today we are here to have a good conversation regarding Digital Personal Data Protection Act, a landmark step in shaping India's, privacy landscape. So to guide us, we have with us Major Vivek. He is a distinguished, privacy expert and practical perspectives on this particular topic, DPDP. Vivek, most welcome to the call, and over to
Thank
you.
you. Thank you, Pratima. Thank you very much. So, good evening, ladies and gentlemen. First of all, thank you for joining this webinar. And on a Sunday evening, you have carved out like an hour of your precious time just to attend this webinar. I really appreciate that. So, before we begin, I just want to introduce the core concept of privacy, right? What is privacy? Privacy is nothing but you are in total control of your data. Right now, what's happening is there are big tech companies, artificial intelligence, which are just prying on our data, trying to squeeze out the data so much, that can help them. And in the entire process, there is a significant harm or risk that translates to us, data subjects. So what has happened over a period of say 60, 70 years, there's been numerous privacy laws that has been enacted. If you go back 70 or 80 years in the United States, in the United States, the very first privacy law that came out was a video privacy law. Back in the days, people used to borrow video cassettes, and there was a judge who happened to borrow some adult video, and that was leaked, which kind of costed him his judgeship. So soon after that, they enacted a video privacy law, and it just followed on. And there were a couple of stalkers who tried to use the driving DMV portal to access the personal information of a female, and they started stalking them. Then they enacted a Motor Vehicle Privacy Act, so on and so forth. There have been numerous privacy acts and regulations. As of today, there are 120 countries which have enacted one or other kind of privacy law. And India, we would say we just kind of realize how important it is for us to have our own law, because we are one of the maximally, or the largest producers of data. Every individual has 2 or 3 mobile phones or 2 or 3 laptops per household in an urban setting. And we generate so much data. Most of the big companies are thriving on the data. There was a saying that a few years back that the wars were being fought on oil, but the new slogan is the next generation war will be fought on data. So with that as a premise, let me quickly jump on to today's topic of discussion, which is Digital Personal Data Protection Act of India. I would be covering my presentation in the following parts. Firstly, I'll be giving you a brief introduction about the Act. The second, I would introduce about the key aspects, and I would deep dive into the key aspects. And the fourth is penalties for companies for not complying with the Act, and what are the way forwards for organization. And I would also talk about career opportunities for people who are looking to get into data privacy. So the Digital Personal Data Protection Act, in short, it's called DPDPA. First, we will look at the scope and applicability. This act applies within the territory of India and only on digital data. If you have data in a digital format, only then this act applies. Secondly, if you're collecting data on a piece of paper and you subsequently digitize it, even then this law applies. And this law applies for personal data collected in non-digital form also and digitized subsequently. And when you look at the data, if the data of our Indian citizens, if it is being processed from outside the country, say if there's some US-based country which is processing Indian employees' data, even then our DPDPA applies. So we know that this law applies for those 2 activities, and let's discuss on where this law doesn't apply. If the personal data is being processed for household activities, for example, I process my wife's personal data for a credit card transaction, or to place an place an online order, this law doesn't apply. This law doesn't apply if the data is being processed for national security reasons. If the government decides that for national security, like I'll probably have to profile someone, I probably have to dig into personal details of someone, DPDP doesn't apply. And third aspect is it does not apply for research and medical purpose. For example, what happened during COVID? Most of us got COVID vaccinations, and government was like tracking us. There was a app which everybody was supposed to download, and they did an exercise called contact tracing. And for when such kind of processing activity which outweighs the personal stuff, the law doesn't apply. And if it also doesn't apply if the data of data subject is being processed for research purposes. And if you look at this act is an attempt to bring harmonized data privacy regime in India. Before this, there was an act called IT Act 2000, which was introduced, and it briefly spoke about data privacy. There was no overarching rule. They only spoke, and it was not. They spoke about data privacy, but it was not practiced. It was not being practiced. But with this harmonized data privacy regime, every organization which handles personal data will have to comply by this. The act also introduces fines on companies as well as data subjects. The fines for company for not complying with the act can go all the way up to 250 crores. And as data subjects, as data principals, if we uh, lodge frivolous complaints or if we do not follow the responsibility the data principal has, even then, we also might have penalty of up to 10,000. And for the first time, like there are like many laws. It is the first time that data principal is also being made responsible. Okay, so for those of you who know other laws like other data protection laws like GDPR, so there is a data subject like which is us, like normal people, and there is a data controller who decides on the purpose and means of processing. In Indian parlance, it is called data fiduciary, and we have a data processor like who on behalf of data controller will process the data. In Indian parlance, it's again considered called as data processor. And we have supervisory authorities or data protection authorities, which is an organization which governs, which enforces that the law is being followed uh, by the corporations. Moving on. So key aspects of DPDP Act 2023. So this, ladies and gentlemen, this is the most, I would say, important piece of the act. I just generally call it as a chessboard. Like as I mentioned, there are like four. Like when if you guys play chess, like you have a king, queen, rook, bishop, and elephant. In the same way, like this board represent like the four actors. If you can look to the left, one is the data fiduciary, which is the organization which collects, which decides on the process and means of processing personal data. The other one is data principal, which is us, like the citizens who share the data. And if you look at the bottom, like, we have a Data Protection Board of India, which acts as a supervisory authority. And these data fiduciaries will contract a data processor to process data on their behalf. So if we master these blocks, like, we can say that if you're looking at a career perspective, a data protection specialist or an data protection officer needs to master like each of these boxes to set up a governance program. So let me go deep dive into like each of them. A data fiduciary, like let me speak about data lifecycle first. It starts with data collection, like when we go out and when we start like probably float a form and we ask our clients or employees to fill in the data. That is where the process of data collection begins. And once we receive the data, then we process it as a company. We process it maybe for XYZ reason. Like if I've collected my employees' information, I might use it for payroll processing. I might use it for background verification, and that is called data processing. Once I finish my processing, either I store the data or I transfer the data to a subsequent, say, processor. In the case, if I pick up payroll processing as an employer, I've collected my employees' data, and I transfer the data to a bank. In this case, I'm a company, and the bank becomes my processor. And then it comes your transparency and accountability, which is I have to be upfront when it comes to collecting the data. I'll have to tell my data subjects or data principals why I'm collecting my data, whether I have a lawful basis, whether I have a legal need to collect data. Only then I can collect the data and process it. So you might have seen that whenever you just log into a website, there is a cookie banner which says that uh, there will be like few cookies used to collect your personal data. Do you consent to it? That is called as like notice. There's also a privacy notice whenever you visit a website. Few of the websites, and say when you visit UK based websites especially, the first thing you see is a privacy notice which says that we would be collecting your information for so and so purpose. Do you give your consent to it? Only after you give your consent, you will be able to access the features of the website. So that is called as your notice. And giving your consent as a data subject, only then you'll have access to the features. That is one. And moving to the data processing, this block, so you should have a basis for processing. Our DPDPA gives you five legal bases. One is based on your explicit consent. A data subject has to give explicit consent for data processing. Then the second one is public interest. Like if you can remember the COVID example, uh, say if the government wants to process the health data to track people who have contracted COVID, that would become your public interest. And the third one is your vital interest. For example, if someone has met with an accident, and you go ahead, you probably look at their you pull their wallet and you look at their license. You have your phone, there is like phone number, contact number, and you try to reach out. That is called vital interest. You can use vital interest to safeguard someone's life. And then you have legitimate, whether you have contract, the relationship between an employer and an employee, it's a contract. I collect my employee's information for, let's say, many processing activities that is being based on contract. And these are the legal basis an organization can depend for processing of personal data. And if you see, data principles, like once as a data principal, if I share data with an organization, I do have some rights. I have the right to access that information. I can reach out to any organization and ask them, like, what data do you have about me? Why do you have it? How long do you have it? If they're maintaining any erroneous data, you have the right to get it rectified. And also, if you do not want a particular organization to have your data, you can always exercise your right of deletion. You can go ahead and say that, fine, I do not like your service. I had contacted with you. I had given you my personal information. At the end of the day, I don't like your service. Kindly delete my data. As per DPDPA, they are required to delete your data and give you a confirmation saying that we don't hold your data anymore and you won't be hearing from us, nor you'll be getting any marketing emails from us. So all this rights are given to data principal by enacting this law. And for example, if you are trying to exercise your right and say a company doesn't adhere to it, so what do? That is when this Data Protection Board of India will come into picture, and they have mechanisms to address your grievances. They can review and appeal if you have any appeal to make. You can just reach out to them. I can say that I, as a data subject, had uh, expressed my data subject access request. A particular company XYZ is not adhering to it. What do I do? And if they investigate and find out that they have faltered on the key tenets of DPDP Act, then they are liable to a penalty which can go all the way up to 250 crores. So it's not like, some company falters on data subject access request, they'll be fined 250 crores. It's up to 250 crores based on where they have faltered on. So for example, it says that you're supposed to get back to a data subject within 30 days. And if the company does it in 45 days, it doesn't mean that, they'll be fined 250 crores. Just for faltering on the timelines, they might get a couple of crores. And if they don't have a process, they might review it and then accord a fine. So I will moving on to the next slide. Okay. So I earlier spoke about consent and consent withdrawal. So consent is a very, very important aspect of any data privacy law. So consent is nothing but, it's my free, specific, informed, and unconditional affirmative action saying that it is okay for a company to collect my data and process it for a particular purpose. So you cannot dupe me into giving consent. It has to be in a very clear, simple, understandable language. Even a person with basic education should understand. Consent has to be that simple. And again, it is one of the legal basis of processing. A company can depend on consent to process the personal data. And consent withdrawal should also be as easy as giving consent. It shouldn't happen that I have gone ahead and given my consent to a company to process my data, and I decide that the services of that company is not that good. And if I want to move away from the company, withdrawing consent, making them stop processing my data should also be as easy as giving a consent. And upon when I withdraw my consent, they should cease processing activities, and they should also give me a certificate saying that, or an assurance saying that we have honored your consent, withdrawal consent, and we're not processing your data anymore. So that should be something which most of the companies should adapt, because this consent, the whole DPDPA will be enforced. At the moment, we are still awaiting the executive regulations are out. We are still awaiting the formalizing of the executive regulations so that this can be enacted. As per me, any rule for that matter will only have teeth once it is enforced. I can say that DPDPA is in place when we start, when the company starts getting fined, and the company starts, adhering to what needs to be done. So that is when a law will be enacted. Okay, moving forward. So as I mentioned, data principals or data subjects, we have certain rights and duties. It is the first time in a data privacy law wherein data subjects have also been given duties, just not the rights. So if I look at the middle column, so as I had mentioned earlier, every data subject has a right to access information what they have shared with an organization. And if they think the organization has faltered, or if the organization have captured erroneous data about them, they have the right to correct, complete, or update those information. And if they are not happy with the way the organization is providing them the services, and if they want to switch to an organization, switch to another organization, they also have the right to erase the data. And they also have another right to complain or to express the grievances against a particular data fiduciary, which can be done at the Data Protection Board. And this right to nominate is another, I would say, a peculiarity of DPDPA, which has not been there in most of the other privacy laws. I can nominate, say, someone to act on my behalf. For example, there are few vulnerable subjects. For example, there can be people who are visually challenged, or who are old, or there are people who are who have special needs. Even they have rights when it comes to organization processing the personal data. but they would not understand like how organization use the data for what purpose. In that case, DPDPA has provided a provision to nominate someone who is in the family or who is a legal guardian to give consent on their behalf. So again, most of the organizations in India are following some or other kind of a privacy law even before this. Like, few healthcare companies or few banks, they are already compliant on GDPR. So again, they will have to slightly monitor or tweak their processes to comply on DPDPA. Organizations do not have to start from scratch. They might have an existing framework and they have to make minor tweaks to comply on DPDP. So until now, I spoke about the data subject rights. Now let me talk about duties. So data subjects or data principal also have certain duties. For example, they cannot make frivolous complaints against data fiduciary. They cannot waste the time of data protection board by making unnecessary complaints or repetitive complaints. If the data protection board finds out that a person is involved in such activities, he or she might be fined like 10,000 rupees as per DPDPA. So with rights comes duties. That's a very unique thing about our DPDPA. Moving forward. So in the last slide, I spoke about data principals obligation. Now I'm going to talk about data fiduciaries obligation. So I'll interchangeably use data fiduciary and data controller because they both mean one and the same. The first highlight is they should give privacy notice, like as and when somebody is collecting personal information, be it on website, be it on a mobile app, they are required to provide a notice, privacy notice to the data principal stating why they're collecting the data, how they are using the data, and how can they exercise their right. And another unique thing about DPDPA is they have mandated that this privacy notice has to be given in 20 plus regional language. So companies now will have to understand, for example, they will probably have to translate their existing notice into the regional language so that any person, like say somebody is accessing a website from Maharashtra, if he or she wishes to read the privacy notice in their regional language, that provision has to be made. So I spoke about the minor tweaks, what company has to do. These are the minor tweaks. They have a privacy notice, but translating that into a regional language, they should start doing it before the regulations come into picture. And I also spoke about the grounds of processing. So the legitimate basis, a company can only process personal data if a data subject has voluntarily given the data, if he or she has provided their consent to process the data, and if it is required for public interest. Remember the COVID, like for a larger good, government did not go ahead and take everyone's consent. We said we will be processing your data, we will be contract tracing you because we are serving a very ulterior purpose, which is safeguard the entire nation. And this can also be used for national security. Like we will not, government will not probably depend on you giving your consent if I have to process your data for national interest. And again, the relationship between employer and employee. If an employer wants to process employees' data, he or she will depend on a contract to process data. So ideally, you're supposed to depend either on explicit consent, contract, to obligate to comply on a law, public interest, and vital interest. These are the 5 legitimate cases a company can depend on, a company, a government, or an institution, or an individual can depend on for processing personal data. And again, most of the privacy laws speak about these legitimate cases. It all stems up from the GDPR. lawful basis of processing. And we are somewhere close to it. We're not exactly a replica of GDPR, but the whole essence of privacy principle is being carried from GDPR. Okay, moving forward, let me have a quick step. Okay, so this is the most debated clause or topic. This DPDPA has introduced a third party called a consent manager between a data principal and a data fiduciary. So as of now, all the privacy professionals or experts are debating on how this consent manager, what role does consent manager play? But as per the DPDPA, the consent for foreign organization to process personal data, if they are depending on consent from a data subject or a data principal, that consent is being managed by a consent manager. That he or she or that organization is a third party organization which would act on behalf of the data subject. So they are liable to the data subject. They have to ensure that the consent that is being taken by them is valid. It is simple. It's easy to understand. And giving consent and removing consent, it is earlier what used to happen. It was we were being dependent on the company, on the data controller or the data fiduciary. But here, this intermediary, the consent manager, they will act on our behalf to ensure that the consent life cycle is managed, it's taken, it is stored, and when revoked, they stop processing our data. So I would say they are a middle layer between a data subject and a principal and a data fiduciary. So how this acts out is nobody knows, because none of the data privacy laws in the world has something called as a consent manager. So we are just still awaiting, because nobody, there are few certain companies, small companies, which have registered themselves as consent manager, but we are yet to see how this will play out. So we'll have to wait and watch. And again, just to give you an insight, they have to be an individual company with, they have to be registered with the Data Protection Board, and they're required to show that they are financially stable. At least the last update what we got is they should have at least 2 crore rupees in to showcase that they are financially stable to play the role of a consent manager. But again, how does it? What are organizations supposed to do? Organizations are supposed to integrate with the consent manager. They have to provide a platform, or they have to integrate with the consent manager's platform to manage the consent. And consent managers also have a role to play to educate the data subjects, how to manage the consent. So they have a very phenomenal role to play, but only time will say how it's going to play out. Moving on. So there are other obligations of data fiduciary. If you look at security safeguards, so Manoj just told me that most of the people who have joined this webinar are cybersecurity professionals. And so just to break it out, whatever, any privacy function, right? It is built over security function. If you look at 27001, which is ISMS, it ensures that data is collected in a reasonable way. It's collected and stored in a secure way. And if you look at ISO 27701, which is a privacy information management system, it is built over ISO 27001. So we as privacy professionals are dependent on security professionals for securing the data. We ensure that the personal data is in compliance with with any of the Privacy Act. So there are certain obligations on companies which collect personal data, which is they have to, when they are trying to store it at rest, it has to be stored at using encryption standards like AES 256. And the data in transit should only happen on HTTPS TLS 1.2 or 1.3. And you should have role-based access controls. It's not that every person in the organization has free access to the data. So certain security and we should have basically have people, process, technology, and organizational safeguards to protect the data. And as of today, I would say most of the organizations have invested in some or other side other security program, but when we get audited by say when for privacy, they also look at our security measures. So it is very important to have a robust security measure to protect the personal data. And one of the other clause is data retention. So when a company collects personal data, it should come with an expiry date. I cannot hold the data what I collect from the data principal for eternity. If I am collecting, say, personal data from my employee, so for say particular purpose like payroll processing, the company law says that Company Act says that I'm supposed to retain the data for 7 years for auditing purpose. And organization may have might retain it for another 1 year just to ensure that if at all there is an audit, they might have to provide that data for audit. But after 8 or 9 years, there is no necessary for company to hold on to their employee data for eternity. So it should be deleted. So if you can recall, data subjects have rights, and when they exercise those rights for data deletion, company should honor it. If they're not legally bound to keep the data, they're supposed to honor it. So this is a very important clause, data retention. So what has happened in the recent past with storage becoming cheap, companies have started holding on to tons and tons of data, terabytes of data, thinking that it might come in handy sometime. Now with AI coming into picture, companies are just which is AI is data, data hungry. They're just feeding tons and tons of data. And without us realizing, it might translate into a significant harm to data subject. Hence, the privacy law emphasized that data can only be stored or retained for a particular purpose, for particular duration, not beyond that. And coming on to the next one, data breach notification. See, companies might have the best of the security solutions, best of training and everything. In case there is a data breach, so there are certain obligations on data fiduciary that they should have taken reasonable steps to prevent a data breach. In case there is a data breach, there's an obligation on the data fiduciary to inform the data protection board and the data subject about the breach so that the data subject or the data principal can safeguard themselves from any negative harms which may arise from data breach. And if at all such kind of breach gets reported to data protection board, they will do a thorough investigation on how did the data breach happen, why did it happen, did the company or the data fiduciary took adequate measure to prevent this from happening, or it just happened because of negligence. Were the employees adequately trained on how to handle data? So these are the things that will get checked when the data protection board starts investigating data breach. And until now, since we did not have a data protection law, breach was being reported to CERT. But now, within 6 hours, CERT says that any breach has to be reported to them within 6 hours. But now, there is an additional obligation of reporting it to Data Protection Board. We'll have to register with the Data Protection Board, and we also have to find out a medium on how we can inform our data subject if at all there is a data breach. So these are the additional things companies must start working on to become compliant on the data protection, Digital Personal Data Protection Act. Moving on. I also spoke about guardian consent and children's personal data. If at all there is any vulnerable subject, be it people with special needs, people who are old, and children, they're all considered as vulnerable segment of people. Uh, so they can nominate someone for processing their personal data. And again, what companies have to do, they have to have a mechanism to identify these vulnerable subjects, be it children or be it people with special needs, and they have to provide them a separate portal or a separate mechanism to provide their consent. And the other obligations, which is very important for a data fiduciary or a significant, okay, let me introduce the word significant data fiduciary. So data fiduciary can be one, for any company which collects personal data. If that personal data consists of, like, say, my religion, my sexual orientation, my health data, like my financial data. So some data which is which if it falls into wrong hands or if it is being processed in a wrong way can impact me as a data subject. So that particular organization will become a significant data fiduciary. They have special requirements, like they need to appoint a data protection officer. So a data protection officer is the one who is responsible for all those squares which I showed. He's the one who acts as an authority when it comes to all matters pertaining privacy. And they are supposed to appoint an independent data auditor. They have to get themselves audited every year on the practices of data privacy. And they are required to conduct a risk assessment, which is data protection impact assessment, on how they are processing personal data and what impact it has on data subject. Whether if it is an adverse impact, what controls do you have to mitigate those impacts? So as of now, as per my experience, just in Bangalore, there are more than, say, like 8,000 companies which would qualify as significant data fiduciary, and less than 30% has a role of data protection officer, a dedicated data protection officer. And the other 30-40% companies, probably the CISO or a CTO or a CIO is acting as a data protection officer. Uh, if they are qualified enough to act as a data protection officer, there is no harm. If just the title is being added to them just to ensure that we are compliant on the law, then they are in thick soup, because you need to understand the law, you need to understand the nuances of the law, and you need to understand, like, if someone falters in the data processing activity, what kind of harm gets translated to data subject. So again, it's very important, for companies which do not have a DPO to have a DPO, get themselves audited every year, and then perform a DPIA as and when it is required. Moving forward. Now, so data processor engagement. Companies cannot operate in silo. For example, they have to depend on a lot of other companies for, like, supply chain, for any other purpose. And if a company is transferring personal data to another company, say my company, we depend on a visa services company, like to get visa for our leadership or for any of the employees who wants to travel abroad. So I have all the data of my employees, and I send that, say, particular employee Vivek wants to travel to US. So I am giving his personal information to this visa processing company. So they are considered as a processor. And I have an obligation towards my employee that I have given him an assurance that whatever data I'm collecting, it is safeguarded. But when it leaves my company and goes to the visa processor, it is my responsibility as a company to ensure that that organization also has a similar level of technical and organizational measures to protect the data and safeguard the personal data. So companies need to do a thorough vendor due diligence before they onboard a processor. They need to ensure that they are a ISO 27001 certified company. They have, like, a DPO in place. They have, like, certain privacy practices, just to ensure that the data which is going to them is also being safeguarded the way we safeguard our employee data. It was just another example. And coming to processing personal data outside India. So most of the organizations based in India, like it's for all the privacy laws. They would want to keep their citizens' data or the residents' data within India, because you never know, like once it lives, the scope says DPDPA applies for processing of personal data within India. What happens if the data goes outside of India? It can be used for any purpose. Uh, there is a FISA Act, which is a Foreign Intelligence Service Act enacted by US after 9/11, wherein they want to snoop in on all the conversations or communication which is coming to their country. And with that, there is loss of privacy. So what government has says is, it is following a restrictive approach, saying that there are certain countries which upholds privacy of their individuals. For those countries, we can transfer data, and there are other countries which blatantly ignores human rights, or which kind of snoops in on privacy of data. Then we can take a call. We can see how we can transfer the data to such countries. It can happen. There's something called an adequacy decision in GDPR, and there is something called appropriate safeguard, wherein you can get into a standard contractual clause, or you can have a certification mechanism, or certain code of conduct. You can depend on like a few appropriate safeguards to transfer data from India to other countries. And again, this is being like monitored very closely by the government. As you can see, they are allowed unless restricted by the government. If there are certain data, if you say for example, DeepSeek, government gave an advisory that be very careful when you use certain AI solutions like DeepSeek, because certain countries are known to infringe upon the privacy of individuals. So government is very cautious about like what we send and out of our country. So companies which has operations in different countries, for example, say Accenture, they are present in like almost like 150 plus countries. So they have to find out, they have to depend on a mechanism on how they can share data with their other branches. And for that, they will be depending on certain modalities like adequacy measures or appropriate safeguards. And there are certain exempted countries which will be published by the Data Protection Board, and companies have to look into those exempted countries before transferring the data. So they're all operational stuff. And once the law comes into play, we will have more clarity on it. Moving on. Okay, law exists for a reason. For example, few years back, government passed a law that, or traffic law that, everybody has to wear helmet, and people violating on that, they were fined like somewhere close to 500 to 1,000 rupees. And it's the same thing. Law has been enacted, and if the companies do not follow or do not adhere to DPDPA, they're in for a ride. Uh, the fines can go all the way up to 250 crores. And Data Protection Board, as a supervisory authority, or they have the power to issue penalties up to 250 crores. And if you look at this, if they are not observing the obligations to give the board or affected data principal notice, they can get fined up to 200 crores. If there is any breach in observance of additional obligation, it can go up to 150 crores. So they have they're following a tier-based approach, wherein fines can range from 50 crores to 250 crores, depending on what they have faltered on. So again, we'll get to see once it becomes operationalized, once the government, the Data Protection Board starts levying fines, only then these things will be clear. And as I mentioned, there is a penalty on data principal also, for if you do not observe your duties, if you start using frivolous means, unnecessary complaints, you might get fined up to penalty of 10,000 rupees. Moving forward. So way forward for organizations. So most of the organizations, big organizations or medium-sized organizations, are compliant on like one or other privacy laws. Most of them align themselves to GDPR because it's considered as the gold standard of privacy laws. So uh, they have to perform like certain minor tweaks to be compliant on DPDPA. So there are certain key actions. They'll have to understand what is the current state, and they have to identify. They have to do a gap assessment and identify uh, what is lacking, and they have to like bridge the gap from the current state to the required state. So that is one. And they will have to prepare an inventory of the data the company is holding. Like there are companies which have been holding on to like tons or petabytes of data. They'll have to identify what kind of personal data they've collected over the years, and they will also have to identify if the data is leaving their company and going to a processor. What are the obligations that have to be levied on the processor? They'll have to identify that. And there are a total of, say, 8 to 10 policies which form a part of privacy governance program, right? From like, privacy notice, privacy policy, cookie policy, breach management policy, data subject access right policy. So companies have to probably hire a lawyer and draft these policies. It doesn't end with drafting the policies. It has to be like, institutionalized, sensitized within their workforce on like, on the adherence to the policies. And I spoke about the consent mechanism. They'll have to think on how to integrate the consent manager with the existing framework. So how are the consents being managed? They'll have to think on those. And for companies which have never adhered to data subject rights, they'll have to have a mechanism on how to support data subject access requests. Like how can a data subject access his data, or how can he rectify his data? They have to put a mechanism for that, and also have a breach management mechanism. If at all there is a breach, how do they contain the breach? How do they communicate the breach to the data protection board? And how do they communicate that to the data subject? So whatever we discussed earlier has to be institutionalized and worked in a way that they just like follow it on a day-to-day basis. And we spoke about data retention. And there are certain privacy technologies, that can be leveraged by companies. There are certain operational tools, privacy operational tools. If I have to name a few, there's OneTrust, there is Big ID, and there is Security AI. So all those what we spoke about, they have automated in a way that a small privacy team for an organization of say a size 10 to 15,000, a team of like 4 to 5 can manage the entire privacy program by leveraging this privacy operations tools. So company can invest in that. And I'm a very strong believer of training and awareness. A company is only as good as its trained employees, because all of you know that human beings are the weakest link when it comes to security and privacy. So it's very imperative that almost all employees are trained on some aspect of security and privacy. And they have to have a mechanism to look at like the changes that is happening in the privacy ecosystem. They have to constantly communicate with the data protection board. Ignorance cannot be a way out, so they need to like understand if there are any changes to the privacy law. If there's any requirement from the data protection board, they have to be proactive, not reactive. And these are the things the companies are supposed to integrate into their existing process. So moving on. Okay, so I would let me talk about few career opportunities. See, I started as a security professional, like back in the armed forces. Also, I used to do a bit of security compliance, and I moved into emphasis as a senior manager, where I did audits like ISO 27001 and SOC 2 assessments. And that is where I realized, privacy was in a very, very nascent stage, right? Back in 2020. And there were only lawyers who spoke about privacy. And the thing about lawyers doing privacy is most of them, it's not that all of them, most of them do not understand the technical aspects of privacy, right? So there are certain things like you have to first secure your data, only then you can build your privacy program. So security professionals make the best privacy professionals. It's like, I generally give this analogy, uh, like, doctors, they do their medical MBBS, the basic degree, and they go ahead and like specialize in, they do MS or MD or MS to specialize in certain, like, either one becomes a cardiologist or a pediatrician, etc. And there is like something called a super specialty. So I would base privacy as a specialty wherein, like, one who has understood the nuances of security will be a great privacy professional. And as you said, the law mandates that all the significant data fiduciaries are required to hire a data protection officer. So that's another, opportunity to look for. Security professionals who have uh, been in this field for like some time, they do understand the nuances of data and how you secure the compliance, risk management, etc. They can just uh, do like understand basic fundamentals and like pivot into data privacy. And if I have to speak about the roles, one can become a data protection officer, which is the highest when it comes to privacy. It is equivalent to a CISO. The reporting is directly into the leadership or the board. And if you look at, there can be like, consent managers. There can be like, there can be consent managers. There can be risk assessment. There are people who specialize in doing data privacy impact assessments. And there are people who only specialize in operationalizing the data access requests, etc. So the opportunities are plenty. And with AI coming into play, I personally feel uh, it this area, like, of data privacy, security, privacy, and AI governance would still require that human touch. We cannot completely offload it to an AI. It would be this field will be there, like, it is not an emerging field, but this will always be there. And there are a lot of career opportunities which is going to like come up. And I would say, it's good for security professionals if they are open to upskill and learn. It's a great opportunity for them to pursue. And Cybernous also has a privacy course, like, wherein it's a 32-hour course which talks about which covers fundamentals as well as intermediary of data privacy. After completing that course, you can appear for certifications like CIPP and CIPM, and it will uh, uh, make you ready for senior or mid-senior courses, mid-senior level career opportunities like senior manager in data privacy or a DPO. So if you are interested, please reach out to Pratima, and she will fill you in on the details. So thank you very much. I'll take a pause here for any questions.
Okay, team. If you have any questions, feel free to raise the hand. We are going to unmute you from here. So I think Dipin Nair has a question. So feel free, Dipin. I have unmuted you.
Good afternoon. I'm Dipin Nair.
Hi,
I'm
Bipin.
having a small doubt regarding the retention. As he was mentioning, the organization will have an internal policy for retention.
Correct.
And with respect to consent, first I will ask for the retention. If an organization is not having a retention policy, suppose, and it is not written in the DPDP Act, no, it is an open end bracket for the retention purpose. So it will be fully owned by the policy makers to decide the retention period, or is there any legal angle in between that?
Good question, Bipin. First of all, if you see, if there's an organization which is working only in India, as you said,
Yeah.
it is still in a gray area. Like, the law is not saying that. The law gives you the latitude to define your retention period. You cannot say that law is silent on retention period, I'm going to keep it for eternity. It says you define your retention period, you give your business justification, and you adhere to it. So you are supposed to have a data retention policy. Every department is supposed to have a data retention schedule with which they say, like, legal data, we have it for, like, say, there's a legal hold on it. As long as there's a legal hold, we cannot delete it. Company Act says that, the financial information has to be kept for minimum of 7 years. And finance department will come and say, okay, fine, like 7 years is fine. But I never know when auditors will come and ask for like data from like now 7 or 8 years. I would probably want to keep it for 10 years. So it is giving you the latitude, you define it, but you stick to it.
Okay, thank you.
Does that
My
answer
next
your question?
yeah. My next question is regarding the consent. When we are talking about getting the consent from the data owner, we are asking for the consent with respect to the process which will be doing on that particular data. But we are not asking the consent that the data will be processed for analytical purpose or to find out the business insight. Then is there any provisions to ask the consent with respect to AI use on that data?
So you have just hit the nail. First of all, whenever we onboard, I'll give you a personal example. Whenever I contract, whenever I onboard a vendor or anyone, I strictly say that, see, we are getting into, you are providing me a service and I'm paying you for my service. Okay. And if you say, you want to use my data, like for, say, analytics is still fine. If you want to use for analytics, go ahead, anonymize the data and use it for analytics. Even certain GDPR law says that after anonymizing the data, it is no more personal data, and personal privacy law does not apply to it. You can go ahead and use it. But since you spoke about AI, see, once an AI model is trained on your data, you never know like what is happening with that. So it is again left to the data controller, data owner, on whether you want to agree to that training the AI model or not. In my case, I just put my foot down saying that you cannot train your AI models on my data. And if you ask me, like, how do you get to know whether they're adhering to it? Technically, you can do it, but you have to go through that architecture review. And I'm 100% like none of the organizations will allow you to do an architecture review of their product. So what we follow is the legal route, contractual route. We emphasize that our data cannot be used to share or train your AI models. If you look, a few days back, LinkedIn was actually training on our data, and few of the people, privacy professionals, highlighted that, and they give you an option to opt out of it.
Correct.
So,
but my question is, you are correct when it comes to data fiduciary and the processor. But what about the user or the end subject who is suffering because of this AI? Suppose, for example, if I am a user, some company asks for my personal information for processing, for example, PCI-DSS, asking for my card detail. I don't know whether they are outsourcing that process function. Now, if as an user, how can I make sure that my data is not used for AI purpose?
The user, first of all, you'll have to go through the privacy notice, which is written in a way to like confuse most of the user. It's like a lot of jargons. And secondly, if you kind of highlight, if you see technical people, we do get to know that it is being used for like some other purpose, and you can always opt out of it. And I think this is the reason why they have introduced consent managers. Nair. Like they'll probably act on our behalf to see whether it is being used for this particular purpose or not, if the organization is using it for different purpose. So the whole integration of consent management is for this purpose. But again, it's not very clear, but we'll only get to know once the consent manager comes into play.
Okay, thank you.
Thank you, Vipin. Any other questions?
Okay, team, any other questions we have? Feel free to raise your hand and we are going to allow you to speak. Okay, so Karthik has a question. Vivek, I have unmuted him.
Yeah.
Go ahead, Karthik.
Hi, Karthik.
Hello, sir. Thanks for the opportunity. Even we got a very broad picture. And our question is about the career opportunity, because you have mentioned then that the opportunity, it's a mid-size managers only, because I curious that course also it's a 32 hours, because if we complete the 32-hour course, is it sufficient to clear the exam for CIPPE or whatever the course, or we need to do anything extra?
Thanks, I mean, great question. Karthik, right?
Yeah, Karthik.
So, Karthik, see, the objective of the training is firstly is to equip you with the fundamentals and the intermediary of the privacy concepts, and the byproduct of that would be clearing the certifications. I was just like talking to someone else. You require like just 3 hours. There is like a questionnaire set. You do that questionnaire set. You can go ahead and clear it. But that's not the objective. The objective is to make you a privacy professional. And I wouldn't say in 32 hours you become an expert. There is a lot of I would say you will be. It's Do you play chess, Karthik?
Yeah, yes.
Okay. So see, like how to move upon. You know that soldiers can go to blocks. A rook can like traverse the board horizontally and vertically, and bishop can only do diagonally. But there are endless possible moves for that. So once you do this course, you will understand what are the requirements like of the privacy law. And once you start uh imbibing that and applying it, that is when you become a privacy professional. I recently gave an interview for an international bank. You won't believe what kind of questions they asked me. What is the data controller? What is the data? What is data subject right? What is the data fiduciary? 4 questions, which probably any privacy professional will be able to answer. It's a very, very niche field, and people who are taking an interview does not know like what to ask. That is where we are when it comes to privacy. Unlike security, which has matured and you might get grilled on like technicalities, but trust me, when a senior vice president of a company asking me such 4 fundamental questions. So to answer your question, you will be introduced to the main tenets of privacy, and then which will be sufficient for you to clear the exam, and which will be sufficient for you to clear the interview. So the way we have structured the courses, we will not be talking about more theory. It's more practical, more hands-on. Because when I did my course, people gave me a book and said, "You read the book and you'll do it." And in the real world, when I saw the contract for the first time, I was clueless. I didn't know what to see in the contract. So everything was learned. In the real world scenario, like the way Rook goes traverses horizontally and vertically, soldier moves too, that in the chessboard. But when you start playing, there are like endless opportunities. So in the course, that's what you'll learn. How to review a contract, how to do a risk assessment, how to do a data, how to honor a data subject access request. So the practical aspects is what will be taught in the course.
Yeah, understand, sir. Because the most reason, because the question is like, see, we have in the security we have a different background. Okay, but anyway, accreditation is a very important aspect. So when we are enrolling a course, are we focusing in terms of, because even the real time world, we are not getting so much opportunity uh, uh, to implement the all the data privacy until we get the exact rule. That's where my question is. Now I got the higher overall picture on this. Thanks.
Yeah, there are a lot of opportunities, Karthik. In fact, a friend of mine, for an assistant manager job, he is going all the way up to 20-25 lakhs, but he's not finding a right resource. So, I mean, the opportunities are plenty, in fact.
Yeah, thank you, sir.
Okay, thanks, Karthik, for asking the questions. Guys, do we have any other questions? And okay, it's fine. We don't have the question right now. It's perfectly okay. We have also put up the link in the chat. So if you want to book a one-to-one call for joining the privacy program, it is there in the chat. The link is there in the chat. And with that said, thank you, Vivek, for finding your precious time to spend with all of us to give us valuable insight about the DPDP. And yeah, thank you so much, Vivek. And thank you everyone for your time as well.
Pleasure talking to you guys. Thank you. Bye-bye.
Thanks everyone. Thanks. Bye.
Bye.